So John will start, then Jan, then Pete, and then we'll take questions if there are any. John?
All right, thank you, Mark, and thank you to the other panelists for coming out to speak to my paper this morning. The Plenary Power Doctrine is a doctrine that will become much more important in the coming years, not just as a result of the various amnesty proposals that are likely to come out of the White House, but I would say also in the context of how this White House or future administrations deal with the issue of the Guantanamo detainees. And we can get into those issues maybe a little bit later, maybe during question and answer. But probably the most important thing we can do is begin with the basic definition. And the Plenary Power Doctrine is based on the notion that the political branches, the legislative, the executive, have absolute power over the regulation of immigration and have a right to regulate immigration with little to no intervention by the judiciary. This is a doctrine that has existed for over 100 years. It really came to being in the late 1800s when immigration first became a relevant political issue. And we've seen this mindset, this holding from the court that they will not involve themselves in immigration matters because it is such a political issue and that it wouldn't be prudent for them to do so. We've seen this upheld time and time again. But despite this fact, there is a movement by some in the what I will call the anti-plenary power crowd, largely immigration attorneys and others, to erode this power in favor of a judicially administered immigration system. These are groups that would like to see more opportunities for appeal. They would like to see the power of the White House minimized and consequently the power of the people minimized in favor of the alien. They would like to see deportations minimized. But basically they can't do this without chipping away at this plenary power doctrine. Now, theoretically, without this doctrine in effect, the ability of the political branches to decide who shall enter the country and who shall be removed and under what conditions could be abolished in favor of a court-run system. This would take power out of the hands of the electorate to decide who we are as a nation, who we shall be, and the conditions under which people may enter. Well, the Constitution itself doesn't give much direction on the issue of immigration, other than to say that the power of naturalization itself is invested in Congress, one of the political branches. Most of our immigration law, therefore, is statutorily based. It's been written by Congress over the years. The White House has had its own, put its own efforts in terms of executive orders and the like. But as a result of this, probably the best way to explain the immigration issue and the plenary power doctrine itself is to really hear how the court has explained their position on immigration. During the late 1800s, like I mentioned, when the immigration issue became the relevant political issue of the day, in a series of holdings, the court set out its position. The court explained that executive branch immigration officers are the, quote, the sole and executive judges of immigration cases. The court held that no other tribunal, unless expressly authorized to do so, is at liberty to re-examine or controvert the sufficiency of the evidence on which he, the immigration officer, acted. The court also held that the power of Congress to expel, like the power to exclude aliens from the country, may be exercised entirely through executive officers. And we're thinking here, of course, immigration officials, ICE officers, and the like. Now, as to the issue of due process, this is really kind of a key issue here. Everyone who understands the Constitution at the most basic level realizes that as a citizen, if you're deprived of life or liberty or property, you are entitled to a certain amount of due process before the government takes that from you. And the court has held that as far as immigration goes, first, the alien has a lower amount of process that is due than a citizen. But the court has also explained that as to aliens arriving at our shores, quote, the decisions of executive or administrative officers acting within power expressly conferred by Congress are due process of law, and that the order of deportation is not a punishment for a crime. Instead, it's a method of enforcing the return to his own country of an alien who has not complied with the conditions upon which his continuing to reside here shall depend. In other words, the court is saying that he has not been deprived of life, liberty, or property without due process of law. And the provisions in the Constitution applying to securing the right of a trial by jury, or prohibiting unreasonable searches and seizures and cruel, unusual punishments have no application. That's the Supreme Court's own holding. Now, these are really the foundation of the Plenary Power Doctrine. The sentiment has been reiterated time and time again over the past 100-plus years. And there have been a few cracks here and there. Mostly, we've seen efforts by the immigration and attorney groups to sort of chip away at the doctrine, making little small exceptions, again, lower courts largely to carve out exceptions here and there, with the long-term goal, of course, being complete dissolution of the doctrine. Now, as I noted, the court has explained immigration is inherently political. The court has held that they themselves don't, as Supreme Court justices, don't have the capacity or the expertise to handle immigration issues, and they would prefer that these be dealt with those who are the experts in the immigration courts, which of course are separate from judicial courts, and immigration officials in the White House and Congress itself. Just as an example, in 1952, there was a case where a number of aliens, non-citizens who were long-term residents were members of the Communist Party. They were deemed a threat by the White House, and the aliens had appealed it up to the Supreme Court. But just to give you an idea of the way the court looked at this from a political perspective, the court said, look, we're not going to get involved. We're not going to say you can't deport these individuals because, quote, any policy towards aliens is vitally and intricately interwoven with the contemporaneous policies in regard to the conduct of foreign relations, the war power, and the maintenance of a republican form of government. Such matters are so exclusively entrusted to the political branches of government as to be largely immune from judicial inquiry or interference. And, the court continued, nothing in the structure of our government or the text of our Constitution would warrant judicial review by standards which would require us to equate our political judgment with that of Congress. Now, Justice Frankfurter agreed with the majority in this case. He understood that there was a harshness involved in removing a non-citizen who was a long-term resident. But again, touching on the political issue, he held that immigration is a political policy belonging to the political branch of the government wholly outside the concern and the competence of the judiciary. And recognizing this power and this responsibility of Congress, one does not in the remotest degree align oneself with fears unworthy of the American spirit or with hostility to the bracing air of the free spirit. One merely recognizes that the place to resist unwise or cruel legislation touching aliens is the Congress, not this court. And that's really what we're talking about here today. If these organizations or anyone has a problem with our immigration policy, it's important that you petition Congress, the people who are politically accountable, the White House, to change the policy. And as I see it, a lot of these groups, like the ACLU, for example, is involved in a case in Pennsylvania right now. They realize that what they want under immigration law politically probably isn't possible. So instead of going towards Congress and trying to make the case, they're hoping that they can kind of quietly advance their agenda by getting one judge to, in the Pennsylvania case, for example, add a 6-month reasonableness period to a deportation statute, which isn't in the law. Now, this chipping away at the doctrine really came to a head 2 months prior to the 9/11 attacks in a case known as Zadvydas versus INS. It involved 2 aliens, criminal aliens, one of whom was involved in violating various drug crimes, robbery, burglary, theft. Another alien who was involved in a gang-related shooting. He had been convicted of manslaughter. Basically, not the type of people you want in your neighborhood. Well, the White House was doing everything it could to find a place to remove these individuals within the 90-day removal period, which is a statutorily defined 90-day period in which the government is going to try and remove these individuals back to their home country. Well, no other country wanted to take them in. Their own countries didn't want them. Obviously, we didn't want them here. They didn't want them back either. And this took some time for the White House to try and negotiate. We got to about a 6-month period plus where the White House was still trying to find a place to deport these individuals. They were detained during that period. Well, what we really saw in a very close 5-4 decision was a sort of what the anti-plenary crowd wants to see. This is one of the cases they highlight. The Supreme Court decided to arbitrarily write into law the idea that if the White House can't find a place to remove a criminal alien after a 6-month period, and there's no significant likelihood of removal in the reasonably foreseeable future, that the alien had to be released.